Acting Speaker. Now, it's disorderly, Acting Speaker, to respond to interjections, and I'm just on my feet, only 10 seconds into the contribution on the Statute Law Amendment Bill reference to Sovereign 2023, and already, Acting Speaker, the member for Frankston is throwing barbs across the chamber. Let the record reflect that. I will not be, to the member for Frankston's great disappointment, giving a rendition of God Save the King, although I know that is something which perhaps many members of this place could learn from. Now, Acting Speaker, I rise to address, hopefully without interjection, the Statute Law Amendment reference to the Sovereign Bill 2023. And I do so noting the outstanding contribution of the member for Kew. The member for Kew is a new member in this place, and she's a new member of the Shadow Cabinet. And I say to this House, put your money behind the member for Kew. Her contribution, the first time that she has responded to a bill in substance and led a bill on behalf of the opposition through this chamber, should be a textbook example for every other shadow minister for this parliament, and perhaps minister, member for Euroa, and perhaps minister. Now, as I'm on my feet, Acting Speaker, I note the member for Greenvale has returned to the chamber. I do commend the member for Greenvale for the respectful way in which he addressed the bill before the House. I commend the member for Bellarine for the respectful way in which she addressed the bill before the House. I note the outstanding contribution of the member for Shepparton and Polwarth, but I do, Acting Speaker, take issue with the way in which the member for Greenvale addressed the bill before the House. If, Acting Speaker, I wanted a history lesson, Eltham, forgive me. I'm hoping Hansard will make me sound better than I am. In regards to the member for Eltham's contribution, if I wanted a history lesson, I would have referred to Geoffrey Blaney's A Short History of Australia. But no, we got that from the member for Eltham, and we got from the member from Eltham, I think, and I suggest, Acting Speaker, an insight into the Labor government's intent behind this bill. If they were simply replacing like for like, then the members of the government would take into account and agree to the very, very good, well-drafted amendments proposed by the member for Kew. But no, I suspect they won't. I suspect they won't do that. And we should, at this point, actually flag, Acting Speaker, the opposition's intent for the amendments drafted, the textual amendments drafted and submitted by the member for Kew. We intend for those to be considered in the Legislative Council in substance as well, because we know that this government will not move to consideration in detail on this bill in this place, and that is a great shame for our democracy. Now, I note that the member for Kew, in preparing the position of the opposition for this bill, has consulted with a number of groups, including Victorian Bar Association, including the Law Institute of Victoria, the Law Council of Australia, the Samuel Griffith Society, the Australian Monarchist League, the Australian Republican Movement, and the Police Association of Victoria. The member for Kew, Acting Speaker, has done her homework. She has consulted with these groups, some groups that the government didn't have a care or concern to consult with in the first place when this legislation was being drafted. And if they had the care, the courtesy and the concern to consult with these groups, and they would have known pretty early on in the piece, Acting Speaker, that this bill as drafted does not have the broad support of those particular groups, which is another reason why we've proposed, the member for Kew has proposed the amendments that she has. This bill should be straightforward. It should be absolutely straightforward. It should be simply replacing like for like. But this bill does not do that. It goes far beyond that. I would even suggest, Acting Speaker, that Labor appear to have seen this bill as an opportunity to, frankly, diminish the role of the monarch and our sovereign. As members on this side have highlighted, in the Attorney General and Solicitor General Act of 1972, the bill doesn't replace the formal titles of Her Majesty's Attorney General and Her Majesty's Solicitor-General with His Majesty's Attorney-General and His Majesty's Solicitor-General respectively. And I know that the Shadow Attorney-General, the member for Malvern, would be deeply concerned by that omission in this bill. In fact, this bill removes the reference to the Sovereign altogether, so that the roles are simply referred to as the Attorney-General and the Solicitor-General. So why, Acting Speaker, if there wasn't a deeper intent behind the changes in this bill, would this bill not reflect a simple like-for-like change? Now, unlike some of my other colleagues, I wasn't able to attend the bill briefing. I know that I did speak to the member for Kew on behalf of the opposition before that bill briefing was undertaken by the government. I had a very simple question, and that was, how do the changes that the government is proposing in this bill, how are they reflected in other institutions in our state? And I know, because the member for Kew has told me, that that is a question which she posed to the government and which, frankly, she never got a response to, and that deeply concerns me also. Acting Speaker, if the system of government in this state, if our constitutional monarchy is to change to a republic, that must be done by an agreement, as the member for Kew pointed out in her contribution, not only by the majority of Australians, but by the majority of Australians in each state and the majority of states. Now, until that time, we should have respect and regard for the Sovereign, for King Charles III, as not only the King of England, but the King of Australia. But by many of the amendments contained in this bill, they appear to remove references to the Sovereign for no valid reason. And we know that there's no valid reason to alter or remove references to the Sovereign because Australia remains, to this day, the last time I checked, a constitutional monarchy. And any future changes to our system of government is a matter for the Australian people. In fact, I know I'm stating the obvious, but perhaps it would assist members on the government side for me to do so. We will, Acting Speaker, remain a constitutional monarchy until the majority of Australians in a majority of states vote to express their will to change our system of government. Look, Acting Speaker, the Coalition is moving a series of amendments, as I've flagged, to bring this bill back to its original intent and to repair the overreach that this government has initiated with the drafting of this legislation. These amendments seek to update the bill to reflect what should have been brought before this parliament, a simple substitution of terms to reflect the accession of King Charles III in our statute books. And with these amendments, Acting Speaker, the bill will be a straightforward matter of legislative housekeeping to ensure all laws in place in Victoria make correct reference to the Sovereign following the death of Her Majesty Queen Elizabeth II. The relevant acts will be amended only insofar as to switch references to Her Majesty, to her and His Majesty, Queen and King, like for like. If those opposite do not take the opportunity to support these amendments, they need to frankly ask themselves why. Why are they overreaching? Why are they, by stealth, assuming within not only the Cabinet but the Labor caucus a presumption of the will of not only the Victorian people but the Australian people? We've seen this before, Acting Speaker, the way that this government operates, the arrogant way in which this government operates, time and time again assuming the will of the Victorian people and going far beyond their remit and far beyond the will of the Victorian people, and we see that again in this particular circumstance. We do not need to shy away from the fact that Australia is in fact a constitutional monarchy and that we form part of the Commonwealth. Our system of constitutional monarchy has allowed us to maintain remarkably stable government in our country in an increasingly uncertain world, and we should not seek to diminish this in any form. Which is why we've proposed the amendments we have proposed, which is why we will propose those amendments in the other place, and which is why when the government's guillotine drops sharply on the head of this bill and other bills on the government business program, we will be opposing this bill come 5 p.m. on Thursday.